On Mirchi New Jersey, I'm Vijaya, welcoming you to the Immigration Hour, brought to you by Nachman Fulvani Zimovchek, the NPZ Law Group, empowering clients on US and Canadian immigration with quality legal counsel and representation. Founder and managing attorney at NPZ Law, David Nachman, is here. Welcome, David.
Namaste, Adab, Sat Sri Akal, and Kemcho to you, Vijaya, and to all our Radio Mirchi listeners.
Thank you, David. Namaste. And there was recently seemingly good news for religious worker visas. Can you tell us more about that?
Sure, Vijaya, and this is going to require me to take a little bit of a step back to explain the history behind the religious worker visa, which a lot of people don't actually know. But now I'm going to be showing my age by telling you this. But back in 1990, under Immigrant 90, which was a very significant change to the immigration law, we had the implementation of the R visa. That's when it was created. And it was created because what happened was that the H-1B, which before 1990 had no cap, when the cap was created, people were worried that there weren't going to be enough H-1Bs around for religious workers because that's what that's what they took advantage of. In fact, if you take a look at the case law before 1990 dealing with H-1Bs, it talked about religious workers who dealt more with toils of the mind as opposed to toils of the hand. And so what happened was when this cap was implemented for the 65,000, and by the way, 20,000 for the masters wasn't even a thought process at that point. When that limitation was created, they broke out several other types of visas: the O, the P, the Q, and the R. And the R is broken up into three different parts. The first part, R-1s, are for ministers, priests, and rabbis. R2s are for professional religious workers, such as teachers, counselors, musical directors, and fundraisers. And R3s are for individuals with traditional religious functions. Now, the duration for R1s was a 3-year initial grant with a 2-year extension, and these were non-immigrant visas without dual intent, even though you could go to an EB-4 classification from R1s. After an R1, usually within the 5 years, people would actually, the way it would work is after you've had 2 full years of work for a bona fide not-for-profit religious organization, you could move to an EB-4. Now, the problem was that religious worker green cards were clumped together with Amerasians, and they were clumped together with SIJ, which is special immigrant juvenile cases, and those all came under EB-4. And what happened was, over the past several years, there have been so many cases that are SIJ that the uptake on visas just basically depleted the EB-4 altogether. And so what ended up happening is that there's been a tremendous backlog to the point of unavailability in the EB-4 classification. So the question became, for us as immigration lawyers, what the heck do we do with religious workers after the 5 years? So what do we do to keep them here? Well, our firm, because we are incredibly creative, is that we've been taking our religious workers to B1s to try to buy them time. But then what we have to do is we have to keep doing that every 6 months or every year to try to extend it. Because that's, if you take a look back in the law, B1s could actually be used for religious workers. Well, it appears that within the last several weeks, the government became spiritually enlightened, and what they did is they allowed these religious workers now, instead of going outside the United States for 1 full year, what they can do now is they can extend that R1. So essentially, and we're by the way, it's an interim rule. They're taking comments, but it becomes effective immediately, so that's really good. So the downside, unfortunately, so obviously with every good, there's a little bad, and the bad is that the folks have to go outside the country, and they have to present themselves at the U.S. consulates, and that there's risk associated with that. But if they're bona fide religious workers, there shouldn't be too much of a problem. So essentially what this rule does is it reduces disruption to vital services that are provided by not-for-profit religious organizations such as temples, churches, and other religious organizations throughout our country. So that's the good and the bad.
That's the good and the bad. And thank you for spiritually enlightening us on that. There's lots to learn there. And of course, we were talking to David Nachman, the founder and managing attorney at NPZ Law. Immigration lawyers, call them today at 201-670-0006 or simply visit visaserve.com. And when you mention Mirchi, you get that special discount off your consult. Lots more on immigration law, both theory and practice, coming up. We'll be right back. Keep listening to Mirchi. It's hot.